So this was an article in San Francisco, and I got interviewed by David Horowitz. And I just want to say thank you to this reporter, to this journalist, right, who goes out and researches and breaks big stories because he's not afraid to talk about the truth. And I'm glad we've created a relationship. I've told David, check in with me anytime on any topic. You will always hear my opinion. So, Proposition 22 rideshare drivers, labor advocates, I would be one of those, revel in propositions reversal. So, let's go through that there. A California Superior Court judge decision Friday that Proposition 22 is unconstitutional. Represented a milestone in the rideshare and gig worker landscape, one that could pave the way toward better work conditions, gig workers said. Uber, Lyft, DoorDash, and other gig economy giants spent more than $200 million to promote the measure as beneficial for drivers, and it passed in November 2020 with some 58% of the vote. The measure, the companies argued, would allow workers to retain a flexible schedule and grant them benefits such as minimum wage and health stipend. But after the initiative won, some elements of rideshare driving that offered flexibility created during the Prop 22 campaign vanished. We know what vanished. I think they bring that up here in the article. While the court's ruling did not address any of those issues, it makes it clear that the rideshare and delivery driver companies overreached in a measure that made it nearly impossible for gig workers or legislators to alter. Its demise offered great hope to organizers. And I say to those organizers, use my platform, use my voice. Let's push, and be relentless until we come with the victory. Vina Dubal, a UC Hastings law professor who has researched the gig economy and filed a brief supporting the drivers in the case, explained that the court ruled that the measure was invalid because it violated a California rule that limits initiative statutes to a single subject. The court said that Proposition 22 only really protected the economic interests of the companies and did not protect the workers. And because its stated objective was something quite different than what it actually did, it violated the law. I completely concur. Also, the court ruled that the measure took away legislators' ability to provide workers' compensation or create some sort of work compensation scheme for workers, which violated the California Constitution, she said. By the way, the link is underneath my video. Drivers have protested the measure since its passage, holding that gig giants have reneged on promises made during the campaign on Prop 22. So for many, Friday's decision was long awaited and fueled excitement over potentially better conditions down the road. We need to stay course, ladies and gentlemen, and we need to negotiate from a tougher position. Ken Jacobs, chair of the University of California at Berkeley Center for Labor Research, I was just there 2 days ago, and education, said it's a big win for drivers who challenge the law, but only the first stage, and it could take another year until it's resolved. He added that he wants to know what will happen with the Attorney General's lawsuit for injunctive relief requiring Uber and Lyft to classify drivers as employees, which was put on hold when Prop 22 took effect. If this is held up by the California Supreme Court, then we're back into the courts over the issue of them complying with the law, he said. That promised to be a lengthy fight, but it's one gig workers are now far more hopeful about. Sherry Murphy, a 3-year Lyft driver with the advocacy organization Gig Workers Rising, said, I know what it means to be driving without workers' compensation, having a looming threat of an accident with no workers' compensation. I know what it's like to not have proper health care. I know what it's like to not have fair wage or a restroom. So gig workers like me, we're celebrating this huge victory. Dubal said she expects the decision will be appealed in the next 3 to 4 weeks. After the appellate court, she said, it will certainly be appealed to the California Supreme Court. It's possible for someone to file an injunction forcing the companies to comply pending an appeal. However, Dubal said she subjects the companies will not change how they treat workers until forced to do so by the California Supreme Court. We can anticipate this will go on for the next many months, she said. So far, nothing has changed on the road, said one Uber and Lyft driver nicknamed Molhado. Uber and Lyft haven't changed anything. They sent us a text that it's going to continue the same way it is, and they're going to appeal all that shit, he said. All the drivers want is just being paid fairly, that's all. Right now, it's not right. They're taking too much money out of the rides from us. So that message went out to drivers on Saturday, according to an email obtained by Mission Local with the subject line, Prop 22 remains in effect. We will appeal this ruling and we expect to win. In the meantime, nothing has changed. Prop 22 remains in effect, including all of the protections and benefits it provides independent workers like you, like guaranteed minimum earnings, injury protection, and more, Uber said in the statement. It's also important to say that this ruling does not reclassify drivers and delivery people as employees, preserving the flexibility and independence you have repeatedly told us you value. Independence. With copycat legislation being proposed in other states, Friday's ruling offers an indication of what may transpire elsewhere. In the spring, Uber removed 2 features it granted drivers during the Proposition 22 campaign, features that appear to give workers the agency of independent contractors. Dubal, the U.S. Hastings law professor, said that the act of rescinding these policies was significant. Uber removed drivers' ability to set their own rates with a fare multiplier, stating that 80% of passengers who matched with a driver with a multiplier of more than 1x had declined the higher fare and failed to request another ride with Uber. Here's where I step in. This is the big elephant in the room, said Torsten Kunert, a popular rideshare YouTuber known as the Rideshare Professor, who added he gets some 300 emails a day from drivers. Drivers had their multiplier once, they stepped into their true worth and made money that they deserved to make, and then it was taken away. That's what I said. Uber also stopped showing drivers the details of their next trip unless they accepted 5 of the most recent 10 rides. It was trying to control what I do, which is what an employer does, said James Allen, an Uber driver with more than 4,000 rides. If you're an independent contractor, you adjust this stuff on your own. Kunert, being myself, said that a true independent contractor would be able to set their own rates, work at their own schedule, and can decide where they drive. We have to understand we got a taste, we got an appetizer of what it could be like to be an independent contractor, and that got stripped away, he said, myself. And now it's time to stand up and fight for it, right? You guys know that I always encourage you to fight. What's more, many drivers have expressed confusion of how to get the quarterly healthcare subsidy from Prop 22. The minimum work hours required for stipend only counts time when a passenger is in the car. It's inaccessible to drivers who get insurance through family members or through Medicare or Medi-Cal, and the vast majority of drivers are unaware of the requirements for the insurance, according to a study by Tulchin Research and commissioned by SEIU. Eric Dryberg, field director at the advocacy organization Rideshare Drivers United, said that of the many calls he's had with drivers, just 1 or 2 spoke of receiving healthcare benefits through the companies. Well, Hardo, the Uber driver, said he hasn't received anything. I worked for them for a year and a half, more than 40 hours a week last week, worked 84 hours, haven't gotten shit, he said about health stipend. Kunert, the rideshare professor on YouTube, said he's hoping for drivers to negotiate a hybrid model, somewhere between independent contractor and employee, where drivers can have independent contractor rights and have a voice at the table for better work conditions, including medical coverage. That's exactly what I said. Right now, what they're offering is a very, very watered down version, and you're literally forced to drive around the clock and put in big hours to achieve Uber and Lyft's health coverage, he said. So glad they ended the article on my note. David Horowitz, thank you. You're a hero. And David is one of those San Francisco natives who gets excited whenever City College is mentioned. So check his articles out. He's a great guy, and I appreciate your work, David. We all do. Have a great day. Please feel free to comment. Thank you.